Welcome back to this channel where we provide premium legal content. Today in this video, we'll be looking at another important aspect in our criminal jurisprudence in Nigeria. Well, in our previous video, we looked at the definition of a child. Who is actually a child under Nigerian law? Is a child somebody below the age of 12 or 14 or 17 or even 18? We also looked at the historical precedent, the historical antecedent to the passage of the Child's Rights Act in Nigeria. Recall also that in a video before that, we looked at the likely decision of the court when it comes to a finding that at the time of conviction of the person to be convicted, the person to be convicted is actually a woman. Not only the fact that this person is a woman, but that she is also pregnant. Will the court proceed to convict that woman or hold on and wait for the woman to be delivered of her baby? Well, you might do well to go back and watch this video so that you can get a better understanding as to the likely decision of the court when it comes to a finding in such circumstance. Well, today in this video, we will be looking at the likely decision of the court when it comes to a finding that the person to be convicted is a child. Not just a child, but the fact that the person is someone under the age of 17. Will the court proceed to convict that child of, say, murder or armed robbery or treasonable felony? You know that these three offenses and more are capital offenses in nature. If you look at the provisions of the Criminal Code as well as the Robbery and Firearms Act, the offense or the punishment for these offenses are death sentences. Will the court proceed to convict a child who has committed armed robbery, a child below the age of 17? Well, it is important that we remind you before we answer the question that this channel needs to grow, and you can support the growth of this channel by subscribing to this channel and clicking on the notification button when you do so that you can continue to receive premium legal content that drops on this channel. Now let's proceed to answering the question. By the provisions of section 273 and 272, 271, as well as 303 of the Criminal Procedure Code, it gives a clearer picture as to what the court will likely do in such a circumstance when the court comes to a finding that this person to be sentenced is someone below the age of 17. 371, 372, 373, and 303 of the Criminal Procedure Code, especially that of the Jigawa State, gives us a better understanding. It provides that the court is to remand the child at the pleasure of the governor, meaning that the child is in the legal custody of the governor. Therefore, the implication of this is that a court of law in Nigeria would literally not sentence a child for the commission of an offense that is capital in nature, whether it is armed robbery, treasonable felony, or as well as other capital offenses. Therefore, now you know the likely decision of the court when it comes to finding that the person to be sentenced is a child below the age of 17. In our next video, we will look at other decisions that the court will likely make when it comes to a finding that the person to be sentenced is someone that is insane. Will the court proceed to sentencing an insane person to, say, death or for commission of murder? What will be the likely decision of the court? We would touch on this in our next video. See you on the next video.